All right, let's dive straight into today's explainer. We're looking at a fascinating working paper by Dr. Gaston Ray that tackles the legal earthquake triggered by the Musk versus Altman trial back in the spring of 2026. Now, this isn't just about billionaire drama, not at all. It's actually about the very foundation of how artificial intelligence companies protect, or at least attempt to protect, their multi-billion-dollar models. Dr. Ray, who is a legal counsel and independent researcher, brings forward a really profound analysis here. He asks, are the contracts governing AI actually built on solid legal ground, or are they just a complete illusion? To set the stage, we have to start with this dramatic courtroom admission from April 30th, 2026. Picture this. Elon Musk is under cross-examination in a federal courtroom in Oakland, being grilled by OpenAI's lead counsel. When pressed, Musk just openly confesses that xAI had partly distilled OpenAI's models to train their own model, Grok. And he didn't just admit it, he fully defended it. He stated flatly, it is standard practice to use other AIs to validate your AI. Observers in the courtroom literally gasped. Everyone thought this was a massive litigation gift to OpenAI. But as we're going to see, it was actually the perfect test case to challenge the whole system. So the media immediately framed this as a clear-cut breach of contract. The narrative was super simple. OpenAI's terms of service prohibit using their outputs to develop competing models. xAI used those outputs, therefore xAI broke the rules. Case closed, right? Well, not quite. The importance of Dr. Ray's analysis lies in moving past that lazy assumption. He asks a much deeper structural question. What if the contract prohibiting this behavior is fundamentally invalid in the first place? So how exactly do we unpack this? Well, we have a clear path forward. We'll start by defining the actual technology behind model distillation. Then we'll explore 5 distinct doctrinal pathways, starting with intellectual property, followed by market monopoly and fairness arguments, before wrapping it all up with the cumulative architecture of this case. Okay, part 1, defining the tech, specifically model distillation. Before we can argue the law, we really need to understand the action. So what exactly is model distillation? This is absolutely crucial. It is not code theft. The competing AI developer isn't hacking into a server and stealing a model's foundational weights. No way. Instead, they're simply querying the model through its public interface. They're asking it questions and observing the outputs to derive behavioral mapping. Essentially, they are extracting functional regularities to see how the model gets from a prompt to a plausible answer. It's a totally standard industry practice, but it's exactly what major labs try to ban using what are known as anti-distillation clauses in their ClickWrap agreements. Which brings us right into part 2. Copyright and reverse engineering. These are the first 2 legal pathways where Dr. Reeve vigorously attacks the intellectual property assumptions hiding behind these user contracts. Pathway 1 hits hard with copyright preemption. Step 1, the U.S. Copyright Office has formally ruled that purely AI-generated outputs lack human authorship, meaning they simply cannot be copyrighted. Step 2, because they lack copyright, these outputs are functionally just facts or data, meaning they belong in the public domain by federal design. And step 3 is where the hammer falls. A private company cannot use a standard click-through user agreement to create a pseudo-copyright over public domain facts. You can't use contract law to grant yourself a monopoly over data that federal law specifically chose to keep free and open. Moving to pathway 2, and this position is truly innovative in how it links model distillation to legally protected reverse engineering. If we look at classic software law, under precedents like the famous 1990s case Sega versus Accolade, courts ruled that investigating the functional, non-expressive elements of a market-leading software to create a competing product is actually fair use. Dr. Ray argues distillation is structurally the same thing, if not an even weaker form of it. The distiller isn't copying expressive code. They're just observing outputs to understand the rules. By banning this, AI labs are trying to prohibit the exact type of competitive investigation that courts have historically gone out of their way to protect. All right, let's jump into part 3, monopoly and hypocrisy. This covers pathways 3, 4, and 5, where we move from intellectual property into the realms of antitrust, equity, and trade secrets. Pathway 3 applies the essential facilities doctrine. Dr. Ray argues we shouldn't just view the AI model itself as the product. Instead, the output of a frontier model is a separable, essential input commodity. Think about it. If you want to benchmark or align a new AI today, you absolutely need access to the responses of the leading models. So when major labs coordinate to ban distillation, it starts looking less like they are protecting their property and a whole lot more like an illegal horizontal monopoly restraint under antitrust laws. They're essentially denying competitors an indispensable input. And then we hit pathway 4, the glaring hypocrisy. In law, this is known as the unclean hands doctrine. Remember how major AI labs built their foundational models?
They aggressively scraped the open web, taking copyrighted books, articles, images, you name it, all without consent, and vigorously defended it in court as transformative fair use. Yet, the very second a competitor tries to scrape their AI's outputs to learn, they cry foul and claim it's theft that must be banned by contract. Equity laws simply doesn't let you have it both ways. You cannot claim a foundational right for yourself while using contracts to call that exact same behavior a foundational wrong when someone else does it.
Pathway 5 targets the ultimate fallback argument labs use, which is usually, well, okay, if it's not copyrighted, then our outputs are trade secrets. To combat this, Ray introduces exhaustion at the API boundary. Think of an API like a public toll booth. To have a trade secret, you have to maintain secrecy. But the moment an AI lab sells its output at scale to literally anyone with a credit card, the act of delivery becomes an act of commercial publication. The secrecy completely dissolves. It's exhausted. You just can't sell an informational good to the entire public and then use a contract to claim it's a closely guarded secret.
Finally, we arrive at part 4, the cumulative architecture, the compounding avalanche.
Because here is where it all comes together. The importance of this analysis isn't found in any single isolated point. It's the cumulative architecture. These aren't just 5 separate complaints. They form an absolute avalanche. Dr. Ray demonstrates that these anti-distillation clauses are attempting to use private fiat to do what the rest of the legal system expressly forbids. They try to preempt federal copyright law, prohibit protected reverse engineering, illegally foreclose competition, operate on massive hypocrisy, and resurrect exhausted trade secrets. When you stack those 5 pillars up, these terms of service look like highly vulnerable and likely unenforceable legal overreaches.
So we're going to wrap up this explainer with Dr. Ray's provocative underlying question. Are the rules governing the production and ownership of AI cognition simply too foundational to our future to be settled by a company's click-wrap agreement? As this legal theory gains traction, it really leaves us wondering, is the entire ecosystem of AI ownership currently relied upon by the biggest tech giants nothing more than a house of legally void cards? It is a huge paradigm shift, and for sure one we will be watching very closely as these court battles unfold.